Hello, hi. Welcome to Let's Talk. Today's topic is family law. We are going to talk about divorce and adoption. What are your rights when you're faced with a divorce? Under what circumstances can you ask for a divorce? And how can you adopt a child? And for that, we have an experienced lawyer, uh, Mr. Shanker Sundaram, to join us here today. Welcome, Shankar. How are you?
Thank you, Dato. Thank you. Thank you so much for inviting me. How are you?
I'm good. I'm good. Okay, just
How's
a minute.
MCO
We
treating
just
you?
sort of the things. MCO.
Mm.
Same as everybody. I think we're just trying to keep ourselves occupied and use this time in a useful manner.
Yes, huh?
How are things with you?
So far, so good. Nothing has changed so far. Keeping occupied.
Okay.
Mm.
Okay. So today we are talking about divorce.
Mm.
Okay, and I just like to say the common misconception, when people come to a lawyer and they say, why do lawyers do divorce cases? It is such a bad thing. You're separating people. Why are you doing this? What are your
It's
comments about it?
well, Dato, I get it very often too. This kind of questions where they actually throw out a lot of tantrums against lawyers, saying that we are committing sins, we are doing something very bad, we shouldn't be doing this, and so on and so forth. But I think I take it as a job where I believe the lawyers actually do not initiate or encourage separation. Couples already separate, and we are just legalizing the separation. Just like when a two-person, a woman, man and woman, wants to be united in name of love, they go to a priest or wedding registrar, in order to unite the marriage. I mean, to unite them, to legalize the marriage. I believe they need lawyer to legalize the separation. Only then the rights of parties can be really ascertained, especially when it comes to rights of the children, wives, maintenance, alimony, we call it, and maintenance for the wife, maintenance for the children, and a matrimonial property which was brought by both parties. And so all sort of things need to be sorted out properly before they separate, in order to do in order to avoid any sort of conflicts. And I believe lawyers are meant, you meant to appoint a lawyer to do all this. You cannot be doing yourself. So in that sense, I believe maybe we should be able to come up with it all this letter too. We should be able to avoid this. And I'm not really sure why the public is kind of giving us this image, but I think we should be able to come up with that.
What is
Yes,
the difference between divorce and annulment?
Oh, divorce and annulment. Okay, Dato. Divorce is something which you only can go and apply to the court upon 2 years after marriage. 2 years after marriage, and where all sort of reliefs will be sorted out by the parties, such as maintenance, maintenance for the children, maintenance for the wife, matrimonial property, and so on and so forth. Everything will be sorted out properly, and everything has to be discussed thoroughly over there. I mean, the parties will usually go to divorce upon 2 years after the marriage. But annulment is something where they wish to annul their marriage before the 2 years itself. Annulment has two limbs, Dato. Basically, it's a void marriage or voidable marriage. Void marriage means a marriage should not have taken place at all, meaning it's illegal marriage. Marriage between two underage people, or marriage between incest, and marriage between the marriage should not have taken place at all. That's what we call void marriage. Voidable marriage, in another sense, is marriage between two persons. Of course, it can proceed, but in the event if any of these limbs were to happen, which is one party is incapable of consummating the marriage. I mean, in plain English, in openly, we can say one party is incapable of having sex, or one party is willfully refusing to have sex, another one party was under duress, or was compelled into the marriage. And of course, all these limbs will come into annulment. So if any of these things were to happen, of course, they can annul their marriage within 2 years, before the marriage, or even they can, annul the marriage upon 2 years as well, as long as any of this were to happen. That's all, Dato. I think in going for annulment, there is not much of reliefs which you can pray. I mean, if there is children, of course you can go, but there's nothing much there. But divorce, yes, it's a larger, to the larger extent, to the larger. It's a widen. The horizon is more widened over there. You can pray for all sort of reliefs, and it will be granted. I mean, if it's reasonable. In Malay, we can annulment. We can say it something like pembatalan perkawinan. Divorce meaning it's pembubaran perkawinan. I'm sure we can differentiate these two limbs right now. The word itself has a good meaning. Pembatalan perkawinan as opposed to pembubaran perkawinan.
No, now,
yes, of course, I'm coming here. If when you talk about pembatalan perkawinan, which is annulment, there are some limbs to be satisfied over there, Dato. There is two limbs over there on the annulment part. One is void marriage, another one is voidable marriage. Void marriage means that the marriage should not have taken place itself. The marriage should not have taken place. It's an illegal marriage. Mostly the marriage is between two underage person, or marriage between incest, or marriage between any prohibitory relationship, and any sort of something like that. The marriage should not have taken place at all. It's an illegal marriage. Then, of course, parties can go to the court and annul their marriage. And there is another limb, is voidable marriage, which is if the marriage already taken place, but in the event if the parties were to still proceed with the marriage, then shouldn't be a problem at all. They want to go and go ahead. But if at all they want to end the marriage due to any sort of reason stated in that particular limb, which is one party is incapable of consummating the marriage, i.e. in plain English, one party is capable of having sex, another one is willfully refusing to consummate the marriage, i.e. in plain English, willfully refusing to have sex, or if at all one party is under duress or compelled into the marriage, or if the wife is pregnant with another man's baby. All sort of these reasons can be used as a ground to go and apply for annulment. So this is what we call pembatalan perkawinan, meaning you want to cancel or you want to just like go and annul the marriage, to nullify the marriage. In certain cases, in certain times, the court will grant the single status back to the applicants. If at all the court has granted your annulment, of course you can go to JPN and request for your status to be single. You can go back to a single, mostly on void marriages. Voidable marriages, I doubt it. But void marriages, you can go back to your status as single. Voidable marriage, most probably they'll put it as divorcee. Now, when it comes to divorce, divorce most probably, under Section 53, you can only apply for divorce upon 2 years upon marriage. When it comes to divorce, before, if at all both parties are consenting to the divorce, of course we can file a joint petition. The both parties has to mutually agree to all the terms, i.e., when it comes to maintenance of the children, maintenance of the wife, matrimonial property, and so on and so forth. Yes, of course we can file a joint petition. But if at all there appears to be any dispute as to any of the sort which is being prayed or claimed by one party against another, then it would be prudent if they refer their marriage to a conciliatory body, which is tribunal in JPN. They have to attend the counseling session, and upon the counseling session, the counselor felt that this marriage has irrevocably broken down. Then they will issue the certificate, and using that certificate, they can go and seek a divorce by filing a single petition, meaning one party suing another party for divorce. And they are asking whatever prayers they thought they wish to have it.
Okay.
I think in legal system, I already explained that's the best.
Yeah, very well explained. Okay, now assuming in a marriage, okay, you see a scenario where the wife or even the husband, they said, "Oh, no, I don't want this divorce. My spouse is asking for divorce, but I don't want to divorce that person." Is that possible to say no to a divorce when the other party wants to divorce?
Well, I have faced this kind of situation numerous times, Dato, to be very honest. The last one was in JBI court, where my client, until the last minute, he refused to accept the divorce, which was proposed by the wife. And the comment by the judge at that point of time was, it take both hands to clap. So, I mean, of course, you can say that you don't want divorce. I mean, it's your right, certainly. But in order to say that, you need to prove, I mean, the other party has to prove the breakdown of the marriages, which is certainly, it's not going to be very hard for them either. So, of course, they can say, but there must be a reason, a strong reason to that. I feel that, the court do not entertain or encourage such a lame stand on these days. That if one party wants to divorce, it would be prudent only to end the marriage properly. I mean, without any sort of further argument or dispute, and make it look messy and ugly.
Say, for instance, the husband is filing for divorce. The wife, what are the things that she needs to take into consideration? What are her rights? Or it works both ways, I know. So can you please tell, when you're faced with the divorce, what are the issues that you must deal with?
Well, so in divorce, I think the women / wife / mother as the upper end, wherein there's a lot of claims which they can make, i.e. they can claim for matrimonial property, they can claim for maintenance for themselves, and they can claim for maintenance for the children. And in previous cases, previously the court was allowing the claim for EPF savings of the husbands as well, and all sort of things. In order to, I mean, each of these claim, there's a certain criteria which you must satisfy to the court. I.e., if you want to claim for matrimonial property of the husband, there must be some sort of, contribution of the wife towards the purchase price of the husband's property. Or if there was a zero contribution towards the purchase price of the property, there must be some sort of contribution which came later. I mean, once they have moved into the house, there must be some sort of contribution by the wife when it comes to the renovation or buying furnitures or helping to improve the house in any sort of ways. Even cleaning the house would deem to be a contribution. So if at all the wife has done any of this, of course, they can claim for the matrimonial property. She can claim the husband's property. And when it comes to maintenance for herself, I mean, if she thinks that she wants maintenance for herself, of course she can claim, but she has to prove to the court that prior to marriage, her lifestyle was different. I mean, before and after marriage, her lifestyle has changed drastically. Meaning, if at all, maybe just say a rich lawyer would go and marry a clerk. Of course, upon marrying her, her lifestyle would have changed a lot, because most probably she's taking her husband's money, about 5,000 ringgit a month, and she's spending lavishly and having drivers and security guard and so on and so forth. And of course, during the divorce, she can ask the court for maintenance from the husband in order to keep her lavish lifestyle, to maintain her lavish lifestyle upon divorce as well. So it's a very fair claim, and the court would allow. But if at all the wife is working and earning somewhere equally to the husband, and she's not relying so much on the husband when it comes to her personal expenses, her personal maintenance, and so on and so forth, I think the court wouldn't entertain such a claim from the wife for maintenance for herself. And of course, when it comes to children, the court has paramount welfare, towards looking at the children. And usually the court will look into the entire expenses being incurred by the children, right from their diapers and up to the university level. Everything will be taken into account, and they will look into the earning capacity of both parties.
With regard to the children, okay, how do the courts determine the child, with whom does the child live? Who has the right? Is it with the mother? Is it with the father? Can they separate the children? That means brothers and sisters. One live with father, one live with mother. What do the courts do there?
Okay, when the child is below 7 years old, of course, the paramount consideration will be given to the mother. I mean, of course, the court will consider the children to stay with the mother. unless the husband can rebut the presumption by coming up with tainting any bad sort of reputations against the mother. Of course, the court can consider giving the access to the father. The custody care and control to the father. When it comes to children below 7 years old, the court will usually look into the comfort level of the children. If at all, from the day which was the child was born until the day of divorce, if the child is already under custody care and control and comfort of the father, the court will not disturb. Very rarely disturbs the environment of the child itself. So in that sense, I believe I believe I already answered that. The court will look into the comfort level and the environment, as well as the financial capability of both persons before coming into consideration on who has the best, best way to keep the children. Foster the children as well as bringing up them. But if at all the child is below 7 years old, 90% the mother will get it. My advice would be very simple: to simply talk with the elders, most probably, to any experienced person, to put out all the options properly, to look into the future, and more than their future, they have to look into their children's future. And it's better to actually attend a counseling session. Counseling session, there is a lot of things. Counseling session, they have options to do. They can either go for private, or they can even go to GTN. And upon taking into consideration of everything, if there is no children involved, there is no children in that marriage, most probably it's better to separate. If at all the problems or the dispute arises out of marriage, cannot be settled or cannot be tolerated anymore, cannot be compromised anymore, it's better to separate. But if at all there is a children involving in that marriage, it's better to reconsider, because the children might need the attention of both parents, father and the mother. They need the love, affection, attention of both parents. In my view, it's better to reconsider. Or if at all they still want to separate, it's better to sort out all the relevant provisions, all the relevant things to the children before they separate.
Kokila Vadivelu asked this question.
What is the matrimonial property is rented?
Property is rented. Yeah.
Simple. Anyway, it's a very simple question. Simple answer. If the matrimonial property is rented, the parties can sort out their differences by sitting and discussing whether to sell the property off and take up the proportion equally, or any proportion which they deem to see it sufficient. Or if it's rented, then of course they can sort out their their differences and then take up the rental money, and then they can see what they can do about it. Most probably, these kind of issues will be dealt in a right proportion between the parties, and most probably they can. These are the things which they need to discuss and sort it out among them. If at all they would wants to the court to decide, of course the court is going to do the same. They will ask who wants to have the money, who needs the money more than one person or another. That's all my advice.
Okay. Now, after the divorce, and say the court has granted alimony to the wife, maintenance for the child, for the husband to pay, and what if the husband does not pay? Or one of the parties don't pay? What can they do?
This is also something very common, because 6 months or 7 months down the road, the husband will stop paying. This is something very, very, very common, because by that time, the husband, most probably, he already remarried, or he might have a child on his own, and he would have various other commitments which he cannot handle to pay the maintenance to the previous marriage. So in that occasion, they have a few options. The wife can have a few options, and the most common options which they always do is going to the court and initiate committal application or committal proceedings against the husband. Now, committal application, when it's being proceeded, when it's being heard in the court will usually ask the husbands on the reasons why they cannot pay. And upon taking into consideration all the relevant reasons being furnished in the court. If at all the court is not satisfied, they might commit the husband to imprisonment for somewhere minimum 3 months to 1 year. So that's the best thing they can right now. That's the best option which is there. Of course, there are a few other more options, but I do not wish to suggest because the implication or the effect is not that great. We have tried before, but we haven't got any good outcome on that. But when we start a committal application, when the husband is ought to believe that he is going to imprisonment, yes, the outcome is pretty much very well.
Okay, but say for instance, after divorce, the court has granted pay maintenance 300 ringgit or 1,000 ringgit, and then but that money it's not enough anymore. Okay, say for instance 5 years down the line, what was granted 5 years ago might not be enough today. That's one. Or say for instance, after the court has granted the order for maintenance, the husband loses his job. So what can they do? Okay.
Well, if the husband loses his job, then it's very simple. If he loses the job and if he cannot afford to find another job, or if he has any disabilities along the line, of course he can go back. He can go back to the court. He can file an application called. Oh my God, I cannot remember the application right now. Variation. Of course, he can file the application. File a variation application. Variation application means in Malay we can call it pindaan kepada perintah mahkamah, meaning to say you can go and change the terms which is stated in the order. Of course, the court might have asked you to pay 1,000 ringgit a month for the children and 1,000 ringgit for the wife. But since you are now you cannot work anymore, or you are facing with any disabilities which you can only afford to pay both of them for 500 ringgit, of course you can go back to the court, revisit the court order, and explain to the court, look, at that point of time, I was earning this much, I was able to give, and this point of time, I am not able to earn, and this is what I can give. And upon taking into consideration all the relevant reasons and circumstances, there must be a change in the material circumstances at that point of time. If that all, if this criteria is satisfied, of course, the court will allow the husbands to submit any sort of payments which the court deemed to feel sufficient at that point of time. And with regards to the wife or asking more sum at that point of time, at any recent times, 5 years down the road or 10 years down the road, of course they can go back to the court. If at all the husband is still earning the same amount of not entertained, but if at all if he's earning slightly little bit more, and the court felt that husband should contribute, the father should contribute to the children, the husband should contribute to the wife, of course the court will entertain that. So in both cases, the parties has to go back to the court and file something called variation application, pindaan kepada perintah mahkamah.
Okay, so now before we move on to adoption, is there anything else you'd like to say or advise generally with regards to divorce?
Okay, Dato'. I would like to say something to the young couples and to all these people who wants to seek for divorce. Children born as a result of your marriage isn't your sendirian berhad property. A father enjoys equal right over the children, except in some rare cases. So, to prevent your children from seeing his father upon divorce or causing severe disturbance to the father's access right to the children, and or saying something bad about your ex-husband to your children is nothing but act of a very uncivilized way or a very pathetic mother. I hope the mothers, especially, I'm sorry to say, but in Indian community, this is happening. When upon divorce, the Indian mothers tend to say a lot of bad things about their father, about their ex-husband to the children in order to break or block their access rights towards the father. I think this is something very common we should be able to avoid. And breakdown of marriage is something, a dispute between you and your husband, and the children should not be a victim as a result of that. So please do not take revenge against your ex-husband using the children as a material. Children at all material times should enjoy the attention and love of both parents. If you really don't know how to do, get up and watch some good movies, Hollywood movies, and something like Liar Liar, for example. It's a very good movie. It shows how much the mother, upon divorce, upon separation, still wants the child to get attention of the father. So that you should watch that kind of movies. And another two things, Dato. Things like tali or tali kodi or engagement rings or necklace. In most cases, it has been established that all these things are conditional gift to a wife, to a mother. So as long as you stay in the marriage, you can keep it, you can enjoy it. But upon separation, upon divorce, I don't see why they must hold it. You should return that. On many occasions, it's proven that such items is belong to the ancestors of the family property or family, and it's being inherited by the one after another. So I think the wife should return the same upon marriage. I mean, upon divorce. And I believe I already said about that claiming the husband's property, claiming. And yeah, the one more thing. This isn't about a divorce. This is something which I learned only last year. An unmarried woman is entitled to claim for maintenance for any children born out of deadlock from the biological father. Marriage is not, a marriage is not necessary for this claim. They can appoint a lawyer, they can go to a magistrate court, they can file something called quasi-criminal application, wherein the father will be summoned to the court, and as long as the mother can prove the DNA or paternal test between the father and the child, if it's satisfied by the court, of course the father has to pay some sort of maintenance for the children. The marriage is not necessity at all. The mother needs not to prove the marriage in these circumstances. The impact and the effect and the difference between a traditional marriage and a registered marriage.
Yeah.
Okay. Of course, after 1982, all these couples were previously only tied knot and temples, only have done their traditional marriage, were forced and encouraged to come and register the marriage in order to keep it, legalize the marriage. And of course, many of them haven't still done yet. If at all you're watching, please go and encourage your parents to come and register their marriage now in order to avoid any sort of conflict in the future. They can still do it now. If at all they're married before 1982 and they still haven't registered their wedding and they still haven't legalized their marriage, please do so now, even now. It shouldn't be a problem at all. But like what Dr. asked, in any such conflicts at that point of time, the legal rights, the marriage which has been registered under the Act will prevail over the traditional marriage. But of course, in the traditional marriage, if the person can prove that marriage attended by a few number of peoples, and of course the rights of the parties in that marriage also can be considered in some cases. But of course, up to this date, there is no any conclusive law on that area yet. The Court of Appeal has given two conflicting decisions on this. One is opposed, and one is against this idea. Another one is favoring this idea. So I cannot comment at this juncture yet. Most probably somewhere around in few years time to come, then I will be able to say in much more in a detailed manner.